My name is Jessica Adams, and I graduated summa cum laude from Harvard Law School 3 months ago with $187,000 in student loan debt and the crushing realization that my parents had broken the most important promise they'd ever made to me. At 26, I was supposed to be celebrating the beginning of my legal career at one of Boston's most prestigious law firms. Instead, I was sitting in my studio apartment, staring at loan payment notices, while my younger sister Emma enjoyed a debt-free start to her career as a social media influencer, thanks to our parents paying off her entire undergraduate debt load. The promise had been made when I was 17, sitting around our kitchen table in our comfortable suburban home in Westchester County, New York. My parents, Dr. Richard Adams and Dr. Patricia Adams, both successful physicians, had sat Emma and me down for what they called the college talk. "Girls," Dad had said, his voice carrying the same authority he used with his surgical patients, "your mother and I want you to know that we'll support your education completely. We've been saving for years, and we want both of you to graduate from college and graduate school without the burden of student loans." "That's right," Mom had added, reaching across the table to squeeze my hand. "We believe that education is the best investment we can make in your futures. Whatever career paths you choose, we'll make sure financial constraints don't hold you back." The conversation had shaped every major decision I'd made for the next 9 years. I'd chosen Harvard for undergraduate studies because it offered the best pre-law program, despite the enormous cost. I'd spent 4 years working hard to maintain the grades necessary for law school admission, confident that my parents' financial support would allow me to focus on academics rather than part-time jobs. When I was accepted to Harvard Law School, ranked #1 in the nation, I'd accepted immediately, knowing that the $200,000 plus its cost would be covered by my parents as promised. Emma, 2 years younger, had taken a different path. She'd chosen to study communications at a state school, graduated with modest grades, and spent the past 3 years building a social media presence that generated decent income through sponsored content and brand partnerships. Her total undergraduate debt had been around $85,000, substantial but manageable compared to my law school obligations. Throughout law school, I'd checked in regularly with my parents about the financial arrangements. Every semester, when tuition bills arrived, I'd forward them to Dad's office, and payment would be processed promptly. I'd assumed the same system would continue after graduation, with my parents either paying the accumulated debt directly or providing me with funds to handle the payments myself. That assumption had been shattered 3 weeks ago when I'd received a text message from Mom that would fundamentally change my relationship with my family forever. "Jessica, honey, we need to talk about your student loans. Can you call when you have a chance?" I'd called immediately, expecting to discuss repayment schedules or consolidation options. Instead, I'd received the news that would destroy my faith in my parents' integrity and fairness. "Sweetie," Mom had said, her voice taking on the careful tone she used when delivering difficult news, "your father and I have been reviewing our financial situation, and we've made some difficult decisions about the student loan commitments." "What kind of decisions?" I'd asked, though something in her tone had already made my stomach clench with apprehension. "We've decided that we're not going to be able to cover your law school debt as we originally planned," Mom had said. "The amounts are just much larger than we anticipated, and we need to be more careful about our retirement planning." The words had hit me like a physical blow. "Mom, you promised. When I was choosing schools, when I was applying to law school, you and Dad promised that you would cover my education costs. We know, honey, and we're sorry. But circumstances have changed, and we have to be realistic about what we can afford." "But Mom, I made every major decision based on your promise to cover my education. I chose Harvard over schools that offered scholarships because you said money wasn't a concern. I focused on grades instead of working part-time because you said I shouldn't worry about finances. Jessica, we understand that this is disappointing, but you're starting a lucrative career. Your law firm's salary will be enough to handle the loan payments." The conversation had continued for another painful hour, with my parents explaining their changed financial priorities while I tried to process the betrayal of their broken promise. What made the situation even more painful was what I had learned during that call about Emma's situation. "Actually, honey, there's something else we need to tell you," Dad had said, taking over the conversation from Mom. "We've decided to pay off Emma's undergraduate loans completely." The revelation had been devastating. While breaking their promise to me, my parents were simultaneously fulfilling their obligation to Emma, despite the fact that Emma's debt was much smaller and her earning potential significantly lower than mine. "Dad, I don't understand. You're telling me you can't afford to help with my loans, but you're paying off Emma's debt entirely?" "Emma's situation is different," Dad had explained. "Her debt is much smaller, and her income isn't as predictable as yours will be. Her debt is smaller because she chose a state school instead of Harvard," I'd pointed out. "I chose Harvard because you promised to cover the costs. If I'd known you were going to break that promise, I would have made different decisions." Jessica, you're being dramatic, Mom had said. You'll be making six figures at your law firm. Emma's income from social media is much less stable. The conversation had ended with my parents insisting that their decision was final and fair, while I'd hung up feeling betrayed and manipulated. Over the following weeks, as I'd processed the full implications of their decision, I'd realized that this wasn't just about money. It was about fairness, integrity, and the fundamental question of whether my parents' promises could be trusted. Emma had always been the favored child, despite my superior academic achievements and career prospects. She was more social, more charming, and better at managing our parents' expectations and emotions. I was the serious, driven daughter who achieved excellence but somehow never received the same level of emotional and financial support. The loan payment notices arriving in my mailbox every day served as constant reminders of my parents' broken promise. $187,000 in debt at 6.8% interest would require monthly payments of approximately $2,250 for the next 10 years. Despite my impressive starting salary at the law firm, those payments would significantly impact my ability to save money, buy a home, or build financial security. Meanwhile, Emma was posting Instagram photos of her new apartment, expensive dinners, and shopping trips, all funded by the discretionary income she enjoyed because our parents had eliminated her debt burden entirely. The inequality was stark and painful, but what bothered me most wasn't just the financial impact, it was the principle. My parents had made a promise, I had relied on that promise in making major life decisions, and they had broken that promise while simultaneously honoring their identical commitment to Emma. As a newly minted lawyer, I understood that broken promises had consequences, especially when one party had relied on those promises to their detriment. I also understood that sometimes the only way to address unfairness was through legal action that forced accountability. 3 days ago, I'd made a decision that would either restore justice to the situation or permanently destroy my relationship with my family. I was going to sue my parents for breach of contract and promissory estoppel, seeking damages equal to the full amount of my student loan debt plus interest and penalties. My parents had taught me the importance of keeping promises and honoring commitments. They'd also paid for the legal education that would allow me to hold them accountable when they failed to live up to their own standards. The lawsuit I was preparing would test whether family promises carried the same legal weight as business contracts, and whether parents could be held financially responsible for breaking commitments that their children had relied upon in making major life decisions. Dr. Richard and Dr. Patricia Adams were about to discover that their daughter's legal education had taught her more than just how to practice law. It had taught her how to seek justice when justice was denied. The law offices of Morrison, Blake & Associates occupied 3 floors of a gleaming downtown Boston tower, and my corner office on the 32nd floor offered a spectacular view of Boston Harbor. As a first-year associate at one of the city's most prestigious corporate law firms, I was earning $215,000 annually, an impressive salary that should have allowed me to enjoy the fruits of my academic achievements. Instead, I was spending my evenings and weekends researching contract law and promissory estoppel doctrine to build a case against my own parents. The irony wasn't lost on me. My parents had paid for the legal education that was now enabling me to sue them for breaking their promise to pay for that same education. But as I reviewed precedent cases and legal theories, I realized that my situation presented a stronger case than I'd initially thought. "Jessica, are you really serious about this?" asked my colleague and friend, Marcus Chen, as he reviewed the draft complaint I'd prepared. Marcus was a third-year associate specializing in contract litigation, and I'd asked him to help me evaluate the strength of my legal position. "Dead serious," I replied, watching Marcus's expression as he read through the detailed allegations I'd outlined. My parents made a clear promise. I relied on that promise in making major financial decisions, and they broke the promise while honoring an identical commitment to my sister. That's textbook promissory estoppel. Marcus set down the document and leaned back in his chair. "Jessica, the legal theory is sound, but are you prepared for the personal consequences of suing your family?" "Marcus, they've already destroyed our relationship by breaking their promise and treating me unfairly compared to Emma. I'm not losing anything that I haven't already lost." Over the past 2 weeks, I'd gathered extensive documentation to support my case. The evidence included email chains from my college and law school years where my parents had confirmed their commitment to covering my educational expenses, bank records showing their payments for tuition and related costs, and most importantly, a series of text messages and emails where they'd explicitly acknowledged their promise while explaining their decision to break it. The strongest piece of evidence was a voicemail my father had left on my phone during my first year of law school. I'd called to express concerns about the increasing debt load, and Dad had called back to reassure me. "Jessica, honey, I know the numbers look scary, but don't worry about it. Mom and I have everything under control. We promise to support your education completely. And we meant it. Focus on your studies and let us handle the financial side. That's what parents are for. The voicemail had been preserved on my phone for 3 years, and I'd had it professionally transcribed and authenticated for potential use as evidence. This voicemail is crucial, Marcus said, reviewing the transcript. It shows that your father explicitly reaffirmed the promise during law school, and his language about meaning it suggests a serious commitment rather than casual parental support. I'd also documented the differential treatment between Emma and me, including screenshots of Emma's social media posts celebrating her debt-free life, and bank records showing that our parents had paid off her loans in full just 2 months before they'd informed me of their decision to break their promise to me. The timing is particularly damaging to their position, Marcus observed. They had the financial capacity to honor both commitments, but they chose to fulfill their promise to Emma while breaking their promise to you. The legal theory I was pursuing centered on promissory estoppel, a doctrine that allows courts to enforce promises even without formal contracts when someone has reasonably relied on the promise to their detriment. My case had all the necessary elements: a clear promise, reasonable reliance, and substantial detriment resulting from that reliance. My entire educational and career path was shaped by their promise, I explained to Marcus. I chose expensive schools because they assured me that cost wasn't a concern. I focused on academics rather than working part-time jobs because they told me not to worry about finances. I turned down scholarship opportunities at other schools because I believed their commitment was secure. Marcus nodded as he reviewed my damage calculations. And you can quantify the detriment. If you'd made different choices, state schools, merit scholarships, part-time work, your current debt load would be significantly lower. The damages I was seeking totaled $203,000, the full amount of my current student loan debt, plus interest and penalties. I'd also included a claim for emotional distress caused by the breach of trust and the disparate treatment compared to my sister. Jessica, have you considered trying to resolve this outside of court? Marcus asked. Family lawsuits tend to get messy quickly, and litigation costs could be substantial. I tried to resolve it through family discussions for 6 weeks, I replied. My parents refused to acknowledge that their decision was unfair or that they have any obligation to honor their promise. They keep insisting that I should be grateful for what they did pay, and that Emma's situation is different. The previous weekend, I'd made one final attempt at family reconciliation during Sunday dinner at my parents' house in Westchester. The conversation had been a disaster that had convinced me that legal action was the only way to achieve justice. Dad, I'm asking you one more time to reconsider your decision, I'd said as we sat around the same kitchen table where they'd originally made their promise 9 years earlier. Honor the commitment you made to me the same way you honored your commitment to Emma. Jessica, we've been over this, Dad had replied with the impatient tone he used when he considered a discussion finished. Your situation is completely different from Emma's. You're earning a substantial salary and you're perfectly capable of handling your own debt obligations. That's not the point, I'd said. The point is that you made a promise. I relied on that promise, and now you're breaking it while keeping your identical promise to Emma. Mom had tried to mediate. Honey, we understand that you're disappointed, but you need to accept that circumstances change. We're proud of your achievements, and we're confident that you'll be very successful financially. If circumstances change, shouldn't they change equally for both daughters? I'd asked. Why does Emma get the benefit of your promise while I get the burden of your changed circumstances? That's when Emma herself had entered the conversation, and the dynamic had shifted dramatically. Jessica, why are you being so dramatic about this? Emma had said, speaking with the casual confidence of someone who'd never faced serious financial challenges. You're making tons of money now. These loan payments are like, what? Pocket change for a lawyer? Emma, the loan payments are over $2,000 per month for the next 10 years. I'd replied. That's not pocket change for anyone. Well, maybe you should have thought about that before going to such expensive schools, Emma had said with a shrug. I was smart and chose a state school because I knew college was expensive. You chose a state school because you couldn't get into Harvard, I'd replied, my frustration finally boiling over. And Mom and Dad are paying your loans anyway, so your smart choice didn't even save you money. Girls, stop fighting, Mom had intervened, but the damage was done. Emma's casual dismissal of my situation and her obvious lack of appreciation for the financial advantage she'd received had crystallized my determination to pursue legal action. Emma, you've never had to worry about money because you've always known that Mom and Dad would take care of your problems, I'd said. I spent 9 years believing the same thing, only to discover that their promises only apply to you. The conversation had ended with my parents insisting that their decision was final, and Emma accusing me of being jealous and entitled. I'd left that dinner knowing that the only way to address the injustice was through the legal system. Marcus, my family has already made it clear that they don't believe they owe me anything, I said, finalizing the complaint I'd been preparing. They've chosen to prioritize Emma over me, and they're comfortable with the unfairness of that choice. The only thing they'll understand is legal consequences. Marcus reviewed the final draft of my complaint one more time. Jessica, this is a solid case. Your documentation is thorough, your legal theory is sound, and your damages are well calculated. But are you absolutely sure you want to proceed? I thought about the question seriously. Suing my parents would likely destroy any possibility of future family relationships. It would generate publicity that could affect my legal career. It would cost thousands of dollars in legal fees and could take years to resolve. But I also thought about Emma's debt-free apartment, her casual dismissal of my financial struggles, and my parents' willingness to break their promise to me while honoring their identical commitment to her. Marcus, I graduated summa cum laude from Harvard Law School because I believed my parents' promise would allow me to focus on academic excellence, I said. They benefited from my achievements and took pride in my success. Now they want to abandon their commitment and leave me with the financial burden while giving Emma the financial advantages. I signed the complaint with the same determination that had carried me through law school. They're about to learn that broken promises have consequences, especially when they're broken selectively and unfairly. The next morning, I would file Adams v. Adams in Suffolk County Superior Court, seeking justice for a broken promise and equal treatment under my parents' financial commitments. My legal education was about to be put to the ultimate test. The process server delivered the lawsuit to my parents' home on a crisp October morning, and my phone started ringing within 2 hours. The first call was from my mother, her voice a mixture of shock, hurt, and anger that I'd never heard before. Jessica, what have you done? Mom's voice was shaking as she spoke. We just received legal papers saying you're suing us. This can't be real. It's real, Mom, I replied, sitting in my office with the harbor view that reminded me daily of the career success my parents had always celebrated. I gave you multiple opportunities to honor your promise voluntarily. Since you refused, I'm seeking legal remedy for your breach of contract. Breach of contract? Jessica, we're your parents, not a business relationship. You made a promise, I relied on it, and you broke it, I said. The fact that we're related doesn't change the legal principles involved. The conversation had deteriorated quickly, with Mom accusing me of being ungrateful and vindictive, while I'd tried to explain that this was about fairness and accountability, not revenge. By the time we'd hung up, it was clear that our family relationships had been irreparably damaged. The second call had come from Emma, and it had been even more unpleasant. Jessica, you're seriously suing Mom and Dad? Emma's voice carried the incredulous tone she'd perfected over years of getting her way through charm and manipulation. This is absolutely insane, even for you. Emma, this doesn't concern you directly, I'd replied. This is between me and our parents regarding their broken promise about my education funding. It absolutely concerns me. You're trying to destroy our family because you're jealous that they paid off my loans. I'm seeking equal treatment under the promises our parents made to both of us, I'd corrected. If they honor their commitment to you, they should honor their identical commitment to me. Maybe they changed their minds because you're acting like an entitled brat, Emma had shot back. Normal people don't sue their own parents. The conversation had ended with Emma threatening to testify against me if the case went to trial, claiming that I'd always been jealous of her relationship with our parents, and that the lawsuit was motivated by spite rather than legitimate legal claims. 3 weeks after filing the lawsuit, I received notification that my parents had hired Davidson, Porter & Associates, one of New York's most expensive litigation firms, to defend against my claims. The irony was bitter. My parents claimed they couldn't afford to honor their promise to pay my student loans, but they could afford to pay premium legal fees to fight my attempt to enforce that promise. Jessica, this is getting serious quickly, Marcus warned me as we reviewed the defense firm's initial response to my complaint. Davidson Porter doesn't handle simple family disputes. They're bringing serious firepower to this case. The defense team's strategy became clear in their first motion, which sought to dismiss my case on multiple grounds. They argued that family promises about education funding were not legally enforceable contracts, that I couldn't prove detrimental reliance because my law degree was valuable regardless of how it was financed, and that the doctrine of promissory estoppel shouldn't apply to informal family commitments. Their arguments are sophisticated but not insurmountable, I told Marcus as we prepared our response. They're trying to characterize this as a family dispute rather than a legitimate contract claim. The breakthrough in building my case came when I discovered that my parents had documented their educational funding commitments in their estate planning documents. During discovery proceedings, I'd subpoenaed their financial records, and their estate attorney had been forced to produce documents that strengthened my position dramatically. "Marcus, look at this," I said, showing him the estate planning memo that had been produced during discovery. Their attorney specifically documented their commitment to provide full educational funding for both daughters through graduate school as part of their wealth management strategy. The memo, dated 2 years before my law school graduation, included detailed financial projections for covering both Emma's undergraduate costs and my law school expenses. It demonstrated that my parents had not only made verbal promises, but had incorporated those commitments into their formal financial planning. "This is huge," Marcus said, reviewing the document. "It shows that they treated the educational funding as a serious financial obligation, not casual parental support." Even more damaging to my parents' position was a section of the memo that specifically addressed the tax advantages of educational funding. Dr. and Dr. Adams can optimize their tax position by utilizing educational gifts to daughters rather than traditional inheritance planning, while ensuring both children graduate debt-free as intended. The document proved that my parents had received professional advice about structuring their educational funding commitments and had made deliberate financial decisions based on their promise to support both daughters equally. The case gained unexpected publicity when the Boston Globe ran a story about the lawsuit under the headline, "Harvard Lawyer Sues Parents Over Broken Promise to Pay Student Loans." The article had been picked up by national media, generating debates about family obligations, educational costs, and the enforceability of parental promises. The case raises fascinating questions about the intersection of family relationships and legal obligations. Legal analyst David Rodriguez had commented in the Globe article, "If parents make specific promises about educational funding that children rely upon in making major life decisions, should those promises be legally enforceable?" The publicity had generated mixed reactions. Some commentators supported my position, arguing that parents shouldn't be allowed to break significant financial promises without consequences. Others criticized me for prioritizing money over family relationships and for using legal action to resolve what they characterized as a family dispute. "Jessica Adams represents everything wrong with entitled millennials," one online commenter had written. "She's making 6 figures as a lawyer and she's suing her own parents for more money." But other responses had been more supportive. "Her parents made a promise, she relied on it, and they broke it while honoring the same promise to her sister. That's not entitlement, that's seeking fairness." The media attention had an unexpected consequence. I began receiving calls from other young adults who had faced similar situations with parents who had broken educational funding promises. Their stories revealed that my situation wasn't unique. "My parents promised to pay for medical school, then changed their minds when my brother needed money for his business," one caller told me. "I'm starting my residency with $300,000 in debt because I believed their promise. I turned down a full scholarship to attend my parents' alma mater because they promised to cover the costs," another said. "Then they decided to buy a vacation home instead and told me to take out loans." The pattern was disturbing and common. Parents making significant promises about educational funding, children making major life decisions based on those promises, and parents later breaking their commitments without acknowledgement of the harm caused. My attorney, Jennifer Walsh from Morrison Blake's litigation department, was optimistic about our chances as we prepared for the preliminary hearing. "Jessica, the discovery process has been very favorable to our position," Jennifer said, reviewing the evidence we'd gathered. "Your parents' own financial documents prove that they treated educational funding as a serious obligation, not casual family support." The most compelling evidence was a series of emails between my parents and their financial advisor discussing their educational funding strategy. In one exchange, Dad had written, "We want to ensure both girls graduate completely debt-free. Educational debt would undermine everything we're trying to accomplish with our wealth-building strategy. The differential treatment between you and Emma is also clearly documented," Jennifer continued. "We have bank records showing they paid off her loans in full just 2 months before informing you that they were breaking their promise." As we prepared for the first major hearing in the case, I reflected on how dramatically my life had changed since discovering my parents' decision. The lawsuit had consumed hundreds of hours of my time, cost thousands of dollars in legal fees, and effectively ended my relationships with my parents and sister. But I'd also gained something important: the knowledge that I was willing to fight for fairness and accountability, even when the personal costs were high. "Jennifer, what are our realistic chances of winning this case?" I asked. "Based on the evidence we've gathered, I'd say we have a strong case for promissory estoppel," Jennifer replied. "Your parents made clear promises, you relied on them reasonably, and you suffered substantial detriment when they broke those promises." She paused, reviewing our trial preparation notes. The harder question is whether the court will be willing to enforce family promises to the same extent as business contracts. We're in somewhat uncharted legal territory. As the preliminary hearing approached, I knew that the next phase of the case would determine whether my legal education would be vindicated through a successful lawsuit against the parents who had funded that education. The irony was perfect, and I was prepared to see it through to the end. The Suffolk County Superior Court courtroom was packed with journalists, legal observers, and family law attorneys who had come to witness what legal commentators were calling the most significant case involving family promises and promissory estoppel in Massachusetts history. As I sat at the plaintiff's table next to my attorney Jennifer Walsh, I could see my parents across the aisle with their high-powered legal team, looking older and more fragile than I'd ever seen them. Judge Patricia Martinez had been assigned to the case, and her reputation for thorough analysis of complex legal issues had given both sides confidence that the case would be decided on its legal merits rather than emotional appeals. The preliminary hearing had been scheduled to determine whether my claims had sufficient legal foundation to proceed to trial. Ms. Walsh, Judge Martinez began, please present the plaintiff's position regarding the enforceability of the defendant's alleged promise. Jennifer stood and approached the podium with the confidence that had made her one of Morrison Blake's most successful litigators. Your Honor, this case presents a straightforward application of promissory estoppel doctrine. The defendants made clear, specific promises regarding educational funding. The plaintiff reasonably relied on those promises in making major life decisions, and the plaintiff suffered substantial detriment when the defendants breached their commitment. Jennifer presented our evidence systematically, starting with the original promise made when I was 17 and continuing through years of reaffirmations and specific assurances. The voicemail from my father during law school was particularly powerful when played in the courtroom. Your Honor, Mr. Adams explicitly told his daughter to focus on your studies and let us handle the financial side. This language demonstrates a serious commitment, not casual parental support. The estate planning documents we'd discovered during discovery were equally compelling. Jennifer showed the court how my parents had incorporated their educational funding commitments into their formal financial planning, treating the promises as binding obligations rather than discretionary gifts. The defendant's own financial advisor documented their commitment to provide full educational funding for both daughters through graduate school, Jennifer explained. This proves that they understood their promises as serious financial obligations. When Jennifer presented evidence of the differential treatment between Emma and me, the courtroom atmosphere became tense. Bank records showing that my parents had paid off Emma's loans in full, while simultaneously breaking their promise to me, created a visual timeline that made their selective breach impossible to ignore. Your Honor, the timing demonstrates that this wasn't about financial inability. It was about choice. The defendants had the resources to honor both commitments, but chose to favor one daughter over the other. My parents' attorney, David Porter from Davidson Porter and Associates, presented a sophisticated defense that attempted to minimize the legal significance of family promises. Your Honor, the plaintiff is asking this court to transform casual parental support into legally binding contracts, Porter argued. If we enforce every family promise as a legal obligation, we'll undermine the informal nature of family relationships and burden the courts with domestic disputes. Porter's strategy focused on characterizing my case as an attempt to weaponize contract law against family relationships. He argued that my parents' statements had been expressions of intent rather than legal commitments, and that circumstances had legitimately changed their ability to provide support. The plaintiff graduated from one of the nation's most prestigious law schools and is earning a substantial salary, Porter continued. She has suffered no real detriment from financing her own education, and her attempt to force her elderly parents to honor promises made years ago is legally unfounded and morally questionable. But Porter's arguments began to fall apart when Judge Martinez questioned him about the differential treatment between Emma and me. Mr. Porter, how do you explain your client's decision to honor their promise to one daughter while breaking their promise to the other? Your Honor, each child's situation was different, and my clients made reasonable decisions based on their assessment of each daughter's needs and capabilities. But, Mr. Porter, weren't the original promises identical? And didn't your clients have the financial capacity to honor both commitments? Porter struggled to provide a convincing answer that didn't acknowledge the unfairness of my parents' selective breach. The most dramatic moment came when Judge Martinez called for witness testimony. I took the stand first, and Jennifer walked me through the timeline of promises, reliance, and breach that formed the foundation of my case. Ms. Adams, how did your parents' promise affect your educational and career decisions? Your Honor, their promise was the foundation for every major decision I made for 9 years, I replied. I chose expensive schools because they assured me that cost wasn't a concern. I focused entirely on academics because they told me not to worry about finances. I turned down scholarship opportunities because I believed their commitment was secure. What impact has their breach of promise had on your current financial situation? I'm facing $187,000 in student loan debt with monthly payments of over $2,000 for the next 10 years. If I'd known they would break their promise, I would have made completely different educational choices that would have resulted in much lower debt levels. When my father took the stand, the contrast between his confident medical practice demeanor and his defensive courtroom responses was striking. Dr. Adams, Porter asked, can you explain the circumstances that led to your decision regarding your daughter's student loans? We realized that the amounts involved were much larger than we'd anticipated, Dad replied. We had to consider our retirement security and our ability to support both daughters equally. But Dr. Adams, Jennifer said during cross-examination, your financial records show that you paid off Emma's loans in full just 2 months before informing Jessica that you were breaking your promise to her. How do you reconcile that timing? Dad's response was painful to watch. Emma's situation was different. Her debt was smaller and her income was less predictable. Dr. Adams, wasn't Emma's debt smaller because she chose a less expensive school, while Jessica chose Harvard based on your promise that cost wasn't a concern? Yes, that's possible. And isn't it true that Jessica's higher income potential was the result of the expensive education that you promised to fund? Dad's inability to provide coherent answers to Jennifer's questions undermined his credibility and highlighted the logical contradictions in my parents' position. The most devastating testimony came when Jennifer played the recorded voicemail from Dad's call during my first year of law school. Dr. Adams, is this your voice telling Jessica to focus on your studies and let us handle the financial side? Yes, that's my voice. And were you reaffirming your commitment to cover her educational expenses when you made that call? I was trying to be supportive. Dr. Adams, you specifically said we promised to support your education completely and we meant it. What did you mean by those words? Dad's struggle to explain away his own recorded words provided the clearest evidence of his conscious commitment and subsequent breach. When Emma took the stand as a witness for our parents, her testimony backfired spectacularly. Porter had apparently hoped she would provide emotional testimony about family relationships and gratitude, but Jennifer's cross-examination revealed Emma's sense of entitlement and lack of empathy for my situation. Ms. Adams, are you aware that your parents paid off your student loans completely? Yes, they helped me become debt-free. And are you aware that they simultaneously refused to honor their identical promise to your sister? Jessica's situation is different. She makes a lot more money than I do. Ms. Adams, doesn't your sister make more money partly because she attended expensive schools based on your parents' promise to fund her education? Emma's response was telling. I don't know why Jessica is complaining. She got to go to Harvard. The callousness of Emma's testimony, her obvious lack of concern for the unfairness I'd experienced, seemed to affect Judge Martinez visibly. After 3 days of testimony and argument, Judge Martinez announced that she would take the case under advisement and issue a written decision within 2 weeks. This case raises important questions about the enforceability of family promises and the application of promissory estoppel doctrine in domestic relationships. Judge Martinez said, I will consider all evidence and legal arguments carefully before rendering my decision. As we left the courtroom, I felt a mixture of exhaustion and cautious optimism. The testimony had gone better than I'd hoped. Particularly, my father struggled to explain his recorded promises and Emma's tone-deaf responses about the situation's fairness. Jessica, I think we presented a compelling case, Jennifer said as we walked down the courthouse steps. Your parents' own words and documents provided the strongest evidence of their commitment and conscious breach. What do you think our chances are? Judge Martinez seemed particularly troubled by the differential treatment between you and Emma, Jennifer replied. The timing of their decisions and their inability to provide convincing explanations for the disparate treatment could be decisive. The media coverage of the trial had been extensive, with legal commentators debating the broader implications of the case for family relationships and contract law. The Adams case could establish important precedent about the enforceability of significant family promises, legal analyst Sarah Chen had written in the Boston Globe. If parents can make specific commitments about educational funding and then break those promises without consequences, it undermines the ability of young adults to make informed decisions about their futures. But other commentators had been critical. Jessica Adams is using sophisticated legal arguments to extract money from her parents, wrote David Martinez in a legal blog. Family relationships shouldn't be subject to contract enforcement, and courts shouldn't become arbitrators of domestic financial disputes. The 2 weeks of waiting for Judge Martinez's decision were among the most stressful of my life. I'd thrown everything into this case. My relationship with my family, thousands of dollars in legal fees, and my reputation within the legal community. If I lost, I would have sacrificed everything for nothing. The call from Jennifer came on a Thursday afternoon while I was reviewing contracts for a client merger. Jessica, Judge Martinez has issued her decision, Jennifer said, and I could hear excitement in her voice. You need to get down here immediately. 20 minutes later, I was sitting in Jennifer's office as she read excerpts from Judge Martinez's 43-page decision. The court finds that defendants made clear, specific promises regarding educational funding that were reasonably understood by plaintiff as binding commitments, Jennifer read. The evidence demonstrates that plaintiff relied on these promises in making major educational and career decisions that resulted in substantial financial obligations. Judge Martinez had ruled in my favor on all major issues. She'd found that my parents' promises constituted enforceable commitments under promissory estoppel doctrine, that I had reasonably relied on those promises, and that I had suffered substantial detriment from their breach. The court is particularly troubled by defendants' decision to honor their promise to one daughter while breaking their identical promise to the other. Jennifer continued reading. This differential treatment undermines defendants' claims that changed circumstances necessitated their breach. The damages award was even better than I'd hoped. Judge Martinez had awarded me the full $187,000 in student loan debt, plus interest and attorney's fees. She'd also included a penalty for the conscious and selective breach of a significant family commitment. The total judgment is $247,000, Jennifer said, smiling broadly, plus your attorney's fees will be paid by your parents. But the most satisfying part of the decision was Judge Martinez's commentary on the broader principles involved in the case. Courts cannot and should not enforce casual family promises or minor domestic commitments, she'd written. However, when parents make specific, substantial promises regarding educational funding that children reasonably rely upon in making major life decisions, those promises may be enforceable under established contract principles. The defendant parents' attempt to characterize their commitments as casual family support is contradicted by their own financial planning documents, their years of reaffirmations, and their selective enforcement of identical promises to their children. Judge Martinez had also addressed the criticism that family promises shouldn't be subject to legal enforcement. The informal nature of family relationships does not exempt family members from basic principles of fairness and accountability. When family promises rise to the level of substantial commitments that reasonably induce detrimental reliance, courts must be willing to enforce those commitments to prevent unjust enrichment and unconscionable harm. As I read the complete decision, I realized that Judge Martinez had done more than just rule in my favor. She'd established legal precedent that would protect other young adults from similar betrayals by parents who made substantial promises and then broke them selectively. Jennifer, what happens next? Your parents have 30 days to appeal, but given the strength of Judge Martinez's reasoning and the extensive evidence supporting her decision, an appeal is unlikely to succeed, Jennifer replied. They'll probably negotiate payment arrangements rather than risk additional legal fees and publicity. That evening, I received a call from my father for the first time since the lawsuit had been filed 6 months earlier. Jessica, Dad said, his voice sounding older and more defeated than I'd ever heard it. We received the court decision today. I know, I replied, not sure what else to say. Your mother and we want you to know that we never intended for things to go this far. Dad, you had multiple opportunities to resolve this fairly before it reached court. You chose to break your promise and defend that choice rather than honor your commitment. There was a long pause before Dad continued. Jessica, the judge's decision, it's very expensive for us. We're going to have to make significant financial adjustments to pay the judgment. Dad, the money you owe me is the same money you promised me years ago. The only difference is that now a court has ordered you to honor that promise. We're prepared to pay what the court ordered, Dad said. But Jessica, this has destroyed our family. Was it worth it? I thought about his question carefully. The lawsuit had indeed destroyed our family relationships, cost everyone thousands in legal fees, and generated national publicity that had affected all of our lives. But it had also established that promises have consequences, that fairness matters even within families, and that parents can't break substantial commitments to their children without accountability. Dad, you destroyed our family when you chose to break your promise to me while honoring your identical promise to Emma, I replied. I just documented that destruction in court. The conversation ended with Dad informing me that they would pay the judgment in full within 30 days, as required by the court order. As I hung up the phone, I realized that my legal education had taught me more than just how to practice law. It had taught me how to seek justice when justice was denied, even when the cost was everything I thought I valued about family relationships. The irony was complete. My parents had paid for the legal education that enabled me to successfully sue them for breaking their promise to pay for that education. Sometimes the best revenge is simply holding people accountable for their promises, especially when they think family relationships protect them from the consequences of their choices. 1 year after Judge Martinez's landmark decision in Adams v. Adams, I was sitting in my newly expanded office at Morrison, Blake & Associates, having been promoted to senior associate based on both my legal skills and the national recognition the case had brought to the firm. The $247,000 judgment from my parents had been paid in full. My student loans were completely satisfied, and I was finally able to enjoy the financial freedom that my legal education was supposed to provide. The case had established important legal precedent that was already being cited in courts across the country. Adams v. Adams has become the leading case for enforcing substantial family promises under promissory estoppel doctrine, legal scholar Dr. Patricia Williams had written in the Harvard Law Review. The decision provides crucial protection for young adults who make major life decisions based on parental commitments about educational funding. The immediate aftermath of the court victory had been both satisfying and painful. My parents had paid the judgment promptly, apparently hoping to avoid additional legal fees and publicity. But the financial payment had done nothing to repair the family relationships that had been destroyed during the legal battle. Emma had been the most vocal in her criticism of the court's decision, posting a series of social media messages attacking both me and the legal system that had forced elderly parents to pay their spoiled daughters' debts. Her posts had generated significant online debate, with responses ranging from support for her position to harsh criticism of her failure to acknowledge the unfairness of our parents' differential treatment. Your sister Jessica earned that money through years of legal work documenting your parents' broken promises, one commenter had written. Maybe instead of attacking her, you should thank her for establishing precedent that protects other people from similar family betrayals. But Emma's response had been characteristically self-centered. Jessica destroyed our family because she couldn't handle not being the favorite child anymore. The comment had revealed more about Emma's perspective than she probably intended. She'd always assumed that our parents' preferential treatment of her was natural and justified, and she'd never considered that their promises to me deserved equal respect and fulfillment. 6 months after the judgment, I'd received an unexpected call from my mother. Jessica, I know we haven't spoken since the trial, but I wanted you to know that your father and I have been doing a lot of thinking about what happened. What kind of thinking? I'd asked, unsure whether this was an attempt at reconciliation or another effort to make me feel guilty about enforcing their legal obligations. We've been talking to a family therapist about the situation, and we're beginning to understand that we treated you unfairly compared to Emma. The admission had been surprising, though it had come too late to change the legal or financial outcomes of our dispute. Mom, I appreciate you acknowledging that, but the damage has been done. You broke a promise that I relied on for 9 years, and you did it while honoring the same promise to Emma. A therapist's validation doesn't undo that betrayal. Jessica, we're not asking you to forget what happened. We're asking if there's any possibility of rebuilding some kind of relationship based on honesty about our mistakes. I'd thought about her request seriously. The anger and hurt I'd felt during the lawsuit had largely subsided, replaced by a kind of resigned acceptance that my parents were flawed people who had made unfair choices. But I'd also realized that rebuilding trust would require more than just acknowledgement of past mistakes. Mom, if you're serious about rebuilding a relationship, it would require genuine changes in how you treat Emma and me. Equal treatment, equal respect, equal consideration for our perspectives and needs. What do you mean? I mean that Emma needs to acknowledge her role in supporting your unfair decision and apologize for her attacks on me during and after the trial. And you and Dad need to demonstrate through your actions that you understand why your differential treatment was wrong. The conversation had ended without resolution, but it had planted seeds for potential future reconciliation based on genuine accountability rather than surface-level family harmony. The most rewarding aspect of the case's aftermath had been the response from other young adults who had faced similar situations. I'd received hundreds of emails and letters from people whose parents had broken educational funding promises, often with devastating financial consequences. Your case gave me the courage to confront my parents about their broken promise to pay for medical school, one letter read. They agreed to honor their commitment after I showed them your court decision and explained that their promise was legally enforceable. Another writer had been even more direct. I used your case as a template to sue my own parents for breaking their promise to fund my graduate education. We settled out of court for the full amount after they realized that family promises can have legal consequences. The broader impact had exceeded my expectations. Law schools across the country were teaching Adams versus Adams as an example of creative legal thinking and principled advocacy. Business schools were using the case to discuss ethics and family governance. and family law attorneys were citing the decision to protect clients whose parents had made and broken substantial financial commitments. Jessica Adams has fundamentally changed how courts view family promises. Family law expert Dr. Michael Chen had written, her case demonstrates that significant parental commitments can be legally enforced when children reasonably rely on those commitments in making major life decisions. The professional opportunities generated by the case had been substantial. I'd been invited to speak at legal conferences about contract law and family relationships. Several law schools had offered me adjunct teaching positions, and Morrison Blake had assigned me to lead their new family promise enforcement practice, representing clients whose relatives had broken substantial financial commitments. Jessica, your experience and expertise in this area are unique, senior partner David Morrison had explained when offering me the new practice leadership role. There's clearly demand for legal services that help people enforce family promises, and you're the obvious choice to develop that specialty. The new practice had attracted clients facing various types of family promise breaches: parents who had broken commitments to fund children's education, grandparents who had reneged on promised inheritance gifts, and siblings who had failed to honor agreements about caring for elderly relatives. The Adams precedent gives us powerful tools to protect clients who have relied on family promises. I'd explained to potential clients. Courts are increasingly willing to enforce substantial family commitments when they rise to the level of binding obligations. One particularly satisfying case had involved representing a young man whose wealthy grandfather had promised to pay for medical school, then changed his mind when the grandson chose to specialize in family medicine rather than lucrative cosmetic surgery. My grandfather's broken promise forced me to take on $400,000 in debt because he disapproved of my career choice, the client had explained. He wanted to control my professional decisions through financial manipulation. Using the Adams precedent, we'd successfully argued that the grandfather's promise was enforceable and that his attempt to impose career conditions after making the commitment constituted bad faith breach. The settlement had covered our client's full medical school debt plus damages for the stress and uncertainty caused by the broken promise. 2 years after my victory against my parents, I'd received an unexpected invitation to Emma's engagement party. The invitation had included a handwritten note. Jessica, I know we've had our differences, but I'd like you to be there for this important moment. Maybe it's time for our family to start healing. I'd debated whether to attend, ultimately deciding that showing up would demonstrate my willingness to move forward if genuine changes in family dynamics were possible. The party had been held at our parents' house, and the atmosphere had been awkward initially, but as the evening progressed, I'd noticed that my parents' behavior toward me had indeed changed. They'd asked about my work with genuine interest, acknowledged my professional success without qualification, and avoided any comments that suggested Emma deserved preferential treatment. Most surprisingly, Emma herself had approached me privately during the party. Jessica, I owe you an apology, she'd said, her tone more serious than I'd ever heard from her. The therapist Mom and Dad have been seeing helped me understand that you were treated unfairly, and that my response during the lawsuit made things worse. Emma, I appreciate you saying that. I also want you to know that I've insisted that Mom and Dad treat us equally going forward. No more preferential treatment, no more assumptions that I need more help than you do. The conversation had been a start, though rebuilding trust would clearly take time and consistent demonstration of changed behavior. At the engagement party, I'd also learned that my parents had established education funds for Emma's future children, and had made legal commitments that those funds would be distributed equally among all grandchildren, apparently having learned the importance of documenting and honoring family financial promises. We want to make sure the next generation doesn't experience the kind of unfairness that damaged our family, Dad had explained when showing me the formal trust documents they'd created. 3 years after filing the lawsuit, I was able to look back on the experience with perspective that hadn't been possible during the emotional turmoil of litigation. The case had cost me traditional family relationships, but it had also established my independence, validated my principles, and created legal precedent that protected other people from similar betrayals. Most importantly, it had demonstrated that accountability was possible even within family relationships, and that principles of fairness and integrity didn't disappear just because the people involved were related. Jessica, do you ever regret suing your parents? A journalist had asked during a recent interview about the case's ongoing impact. I regret that it was necessary, I'd replied. I regret that my parents chose to break their promise and defend that choice rather than honor their commitment, but I don't regret holding them accountable for their actions or establishing precedent that protects other people from similar treatment. The Adams vs. Adams' decision had become required reading in contract law courses, a landmark case in family law, and a symbol of the principle that promises have consequences regardless of the relationship between the parties involved. My parents had taught me the importance of education, hard work, and standing up for what's right. They'd also paid for the legal education that enabled me to apply those lessons when they failed to live up to their own standards. The irony had been perfect, and the justice had been complete. Sometimes the best way to honor your family's values is to hold them accountable when they abandon those values themselves. And sometimes the most important lessons about integrity come from watching what happens when people think their relationships protect them from the consequences of broken promises. The law degree my parents had funded had taught me that justice was possible, even when it came at the cost of everything I'd thought I valued about family loyalty. In the end, that had been the most valuable education of all.